even after making a valid observation that this motion is not worth the paper it's written on. But he impeaches. It tells your lordship that what was happening there was not an impeachment. The Senate and the National Assembly was not in pursuit of good governance. It was not in pursuit of transparency. It was not in pursuit of accountability. It was not in pursuit of the rule of law. It was in pursuit of political elimination. That is what guided the Senate. And your lordship, then you might want to ask yourself, whether such a motion, your lordship, the nexus between the contribution of the members of the Senate and the motion. Wambora 21 says that there must be a nexus. And not just the nexus between about the contribution, but even the particulars that are alleged to have been transgressed and the person facing the impeachment. Your lordship.
I appear, my lords and my lady, instructed by the Honorable Attorney General, and I appear here with Christopher Marwa, Deputy Chief State Counsel. We are happy to confirm to the court that grounds of opposition dated 24th November 2024 have been filed, and written submissions dated 4th March 2026 have also been filed. I propose to address one issue, one fundamental legal issue, in several parts. And that issue is, what are the constitutional limits of this court's jurisdiction over impeachment proceedings, and why both the threshold and the merits of the consolidated petitions have failed. My lord, it's common ground among all counsel here that impeachment is not an ordinary constitutional proceeding. In the words of the Supreme Court of the Philippines, it is a sui generis proceeding, a constitutional measure designed to protect the state from official delinquencies and its political in character. I know it's been submitted by my learned friends repeatedly that these impeachment proceedings are not of a political character. In fact, impeachment proceedings globally are political in character. And there is an article referred to in our submissions, which my lords will find, which is an article that summarizes global trends in impeachment proceedings. In fact, here in this country, the very point that my learned friends deny has been consistently affirmed by our courts. Let us see what the court said in Kaweria Mwangaza versus the County Assembly of Meru and another. Justice Edward Mureithi, your learned distinguished colleague, sitting in Meru, affirmed that impeachment is inherently political and is distinct from the judicial process. So it is sui generis, we all agree. You will look at our submissions at paragraph 22 to 71. Our submission is echoed by the second respondent's submissions at paragraph 50 to 96. And we draw on comparative analysis. We've looked at the United States, the Philippines, South Korea, Brazil, and Nigeria. There are three distinct features about impeachments and other accountability mechanisms. First, and my learned friends have made heavy weather of this, mandatory public participation. But I want to pause there and to remind ourselves, the public is not participating so that it may make the decision whether to impeach or not. That is not the work of the public. The public is participating so that this political process may be informed. Number 2, strict constitutional timelines. And 3, bicameral supermajoritarian requirements, both at initiating it and at the removal. This is not accidental draftsmanship. These are deliberate constitutional choices that vest the impeachment power firmly and finally in the hands of Parliament, and not the courts, in the hands of Parliament. Why? Because Parliament is elected. Parliament is an elected body. Political accountability is to an elected body that we call Parliament. The courts are not elected, and that is deliberate in our constitutional democracy. So we cannot have a counter-majoritarian situation where the elected representatives make a decision which is then reviewed for policy purposes by a non-elected branch. And I will be making it very clear in a very short time. That is not to say that the High Court does not have constitutional oversight over Parliament. It does. The High Court has constitutional oversight over Parliament. What does that mean? That this court, and that's why we are here this afternoon, must satisfy itself that the rights of the petitioner were respected. What can't this court do? This court cannot say, like you have been invited, that why does that particular MP say that this man was rude to another man, therefore he's impeaching him? That is beyond what you can investigate. Kenya, this our beloved republic, we have put a threshold for impeachment that is one of the highest in the world. We have made it more difficult to impeach than any other country that we can think of. You can look at paragraph 66 of the second respondent submissions, and it will illustrate that our criteria is one of the most demanding in the world. Look at the United States that prides itself as the biggest democracy in the world. You require only a simple majority in the House of Representatives to initiate impeachment. In Kenya, you require 2/3, almost an impossibility. Under the old constitution, you require 2/3 to change the constitution. It's a very, very, very high threshold. In the proceedings now before you, my lords, we have 282 members who voted in favor. 44 voted against. That is not a partisan squeak. That is a constitutional supermajority of extraordinary proportions. Some explanation has been given as to why Parliament votes in this way. We have no evidence. No evidence has been brought before you. It's political opinion, and whoever holds it is entitled to it. Let me come now, my lords, to what is your duty in the humble submission of the Attorney General of Kenya. What is the duty of the court when we have reached this point? Should this court proceed to a merit review of the impeachment? Should it relitigate the proceedings as the petitioners very boldly demand? Our respectful answer is that you should not, and you cannot. You must resist the invitation to turn these proceedings into a merit review of the impeachment. If Parliament was full of wise men, would they have reached this decision? If the Senate was full of angels, would they have reached this decision? That is one question you should not be tempted to answer. What, in our very humble view, should you do, my lords, as your duty? your very simple duty is to ask yourselves, was there a violation of the constitutional rights of the petitioner? That's all. Was there a violation of the constitutional rights of the petitioner? That's a narrow, very, very narrow inquiry. This is not my personal opinion. It is the settled jurisprudence of the Republic of Kenya. It is the settled jurisprudence of the Republic of Kenya as enunciated by the Supreme Court of Kenya, the highest court in our republic, in the case of Sonko versus the County Assembly of Nairobi City and against 11 others. This is what the Supreme Court said, and I beg your indulgence to read verbatim. Likewise, in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another, this court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and to inquire into how the County Assembly and the Senate perform duties in which they alone have the discretion, or to review the merit of the decision by the County Assembly to impeach the governor. What does this mean in practical terms for today's proceedings? This court is called upon not to review whether the charges against the first petitioner were approved, not to assess whether the evidence was sufficient, not to determine whether Parliament reached the correct conclusion. This court is called upon only to evaluate whether the first petitioner's constitutional rights to due process were compromised, and nothing more. So heavy weather was made by my very honorable and distinguished learned friends, led by my very own friend, the Honorable P.K. Muigai. Heavy weather was made of all manner of allegations relating to process, who initially was to bring the petition, who ended up bringing the petition. All those are irrelevant. Only one thing is relevant. Were the petitioner's constitutional rights to due process compromised? From where we sit, I am instructed by the Honorable the Attorney General to advise the court that no violations have been demonstrated in the petitions now before you. Further, I wish to submit this. The evaluation you will make, my lords, as to whether the petitioner's constitutional rights were compromised is not an abstraction. It must be anchored in the constitutional text itself. The petitioners must demonstrate that the constitutional right that was violated is this one and that one and that one. No generalities, no obstructions, specifics. This is what we are commanded to do by Article 151, Article 152, Article 144, Article 145. Article 152 provides that the provisions of Article 144 and 145 relating to the removal of the president shall apply mutatis mutandis. We must thank God for a little Latin still left in the Constitution. There was a submission made, unless I misunderstood it, that that there exists only a provision for the impeachment of the president and none for the impeachment of the deputy president. Nothing could be further from the truth, because Article 144 and 145 apply to the removal of the president mutatis mutandis. It is therefore, my lords, Article 144 and 145 that we find the standard. That is where we will find the standard of how the petitioner ought to have been treated. In our very humble submission, my lady and my lords, this petition must fail. This petition will fail not because the first petitioner's concerns are not important. They are very important. But because the remedy he seeks is constitutionally unavailable. What does he ask the court to do? One, he asks you to reopen and re-examine the impeachment proceedings. You have no jurisdiction to do that. He asks you too to re-evaluate the evidence placed before the National Assembly and the Senate. You have no jurisdiction to do that. Three, he wants you to determine whether the constitutional threshold for each ground that he faced was met. Meaning, he's asking you to rehear the proceedings and reconsider the evidence. You have no such jurisdiction. 5, he wants you to quash the resolution of both houses and declare his impeachment null and void. So he's asking you to sit as a court of appeal on the decisions of the National Assembly and on the decisions of the Senate. That is exactly what the Supreme Court in the Sonko case has said no court should do. So my learned friends are flying into a wind, a headwind that they cannot overcome. What they want has already been declared by the Supreme Court as not able to issue from this court. When we look at Article 144, sub-article 8, which applies mutatis mutandis to the Deputy President by virtue of Article 150, sub-article 2, that is the situation the Constitution itself sought to foreclose. I know you will be told, and have already been told, and I've been in your court long enough to know that you've been told this many times, the spirit of the Constitution. Before we look for the ghosts and the spirits of the Constitution, we must look at its plain language. The language of 1448 provides finality to the Senate's decision. On the night that the Senate carried out its vote, your petitioner stood impeached. It did not await any other action by any other body or authority. So Article 1448 provides the finality of the Senate's decision. It's not subject to appeal or review on the merits. On the merits. To accept the petitioner's invitation to sit as an appeal court would be a violation of our Constitution and the law.